Clerk will now proceed to read the orders of the day.
Human Rights Act 1998, Repeal and Substitution Bill, second reading.
No. Charlie Elphicke.
Mr Deputy Speaker, I beg to move that the Human Rights Act 1998 Repeal and Substitution Bill be now read a second time. I brought this bill to the House today because human rights are important. Human rights matter. But human rights are today in crisis, with a substantial majority of the British people regarding human rights as a charter for criminals and the undeserving. And I say a new settlement is needed to restore trust and confidence in human rights with a settlement that works for Britain. Before 1998, the UK had a homegrown human rights settlement that worked and worked well, that had been built up over centuries. It was accepted, even respected, by the British people. In 1998, the Human Rights Act brought the European Convention of Human Rights directly into British law, along with the European Court of Human Rights body of case law. This change has without doubt transformed human rights in the UK in ways that are wholeheartedly rejected by the British people. And it's not difficult to see why it is that there is so much public concern. We see in the newspapers, day after day, week after week, so many cases reported which just give us a sense that a great injustice has happened, that the balance is not right. I'll give you examples. An alleged Rwandan war criminal suspected of crimes in the 1994 Rwandan genocide could not be deported because he could not get a fair trial in Rwanda to answer for his crimes. So he is today to be found driving a taxi round Essex. I don't think that that is the right balance. I don't think most people would think that that is the right balance. A Honduran man could not be deported to answer charges of murder because the family life he had established in the UK since he arrived after escaping custody in Honduras. So he goes and kills someone, comes here, establishes a family, and he is able to use that family as a shield against answering crimes and answering justice for crimes he is alleged to have committed. A failed asylum seeker could not be removed from the UK even though he had committed a string of criminal offences, including a hit-and-run incident in which he killed 12-year-old Amy Houston because the family life he had established in his country illegally. And it strikes, I think, all of us as odd, even thoroughly wrong, that you should be able to, in a moment, you should be able to deny family life to another and yet have it protected for yourself. I give way.
I agree strongly with my honourable friend. What would he say to people who are very concerned about supposed family life being used as an excuse? If a family is together, does it matter where they live in the world, and perhaps the wife or husband and children should move with them to their home country? That is a view that's often put forward. What would my honourable friend say about that?
That's a fair point to be made, but I think you need to look at the individual asserting a right. They say, I establish a family, I have a right to family life, and we say, yes, family life is important, family life does matter. However, if you have taken away the family life of someone else, how can you stand on that right? How can it be right that you should stand on that right? And a key part of the bill that I brought to the House today is that anyone who asserts a right can't just stand on that right and say, that's my right. The courts should look at the wider circumstances of the case, look at the conduct of that person, and see if they come, as it were, to justice with clean hands themselves, have their own conduct taken into account, their own conduct examined, and see if in the round it is in interest of justice that they should be able to assert that right.
Well, my honourable friend, give way.
Yes, of course.
I agree wholeheartedly with what my honourable friend just said, and congratulate him on bringing forward this bill. And he refers to the common law principle of equity, which has always been part of English law, that you can't expect to be able to get a remedy from the courts if you don't come with clean hands. And doesn't he believe that that is really the essence of what we're talking about here? We want to restore the principles of equity.
I agree with my honourable friend, who characteristically makes a very forceful argument. And it seems to me that for too long, human rights have been interpreted under the Convention in what lawyers will call an objective test. Do you have a family? Yes. Do you have a right to family life? Yes. End of story. Whereas the British way, British common law way, is to say, do you have a family? Yes. It's important to preserve that. But have you acted in such a way, subjectively, a subjective test, that that right should not be allowed as far as you're concerned? And I think that's a really important key point that goes to the heart, in my view, of why human rights are in such crisis in Britain today, and is a key plank of the change that I'm seeking to make in this bill. And there are more cases as well. There's a Pakistani man who was found by the deportation tribunal to be an Al-Qaeda operative who posed and still poses a serious threat to the national security of the United Kingdom. And another man who was found to be willing to participate in the former man's plans for a mass casualty attack in the UK. In other words, these people were plotting terrorism. He could not be deported back to Pakistan because of the risk that he might be maltreated by the Pakistani intelligence service. I give way.
Thank you, Mr. Deputy Speaker. I thank my honourable friend. If someone cannot be tried properly in his own country, Mr. Deputy Speaker, the International Criminal Court may well try him or her. I speak as someone that's given evidence for the prosecution in 5 trials in the International Criminal Court, and I think it's quite a good system. It's one way around the problem we have.
Thank my honourable friend for that intervention. He speaks with great experience, not only himself as a war hero, but also as a person who has pursued justice and kept the peace in dangerous places of the world for so many years, and in such a way has he dedicated his life. And I completely agree. I think there should be a system, if we're going to have an international court system where we have to second-guess the justice of other countries and put them down and say they're not good enough and they won't come up to the standards, then maybe there should be an international mechanism where people can be tried and can be made to answer their crimes. And I feel very uncomfortable that someone can go round Rwanda butchering people, committing genocide, and yet today can be allowed to drive a taxi around Essex. I think this is wholly wrong. I think, if nothing else, the passengers in that taxi I worry about, and they won't necessarily know his background and his behaviour, his previous conduct, and they take their life quite literally in their hands when getting into his taxi. And so I think the idea that my little friend makes of an international court for these cases is one that should be explored. Then there was a case of Abu Qatada. Yes, of course.
Very much, Deputy Speaker. The Honourable Member please clarify why it is that the international court should be considered, given that presumably the problem with the European Court on Human Rights is the entire notion of trying to create a set of universal international rights which can be applied irrespective of individual countries or their political codes. Presumably the movement from a European court to an international court would simply exacerbate the problems that the Honourable Member is describing.
I thank my honourable friend for that intervention. I think either would be the way forward. The issue that I'm trying to touch on is the issue around justice in Britain and ensuring that we don't have people going around this country who are a threat to our national security, who threaten the livelihoods of others, who have committed criminal acts, and yet are not answering justice anywhere. We say that because their courts are not safe, they shouldn't face justice at all. I just think that that is just wrong-headed, and I think most of the British people would say that that is wrong-headed and not the right way to go. And let me take the example of Abu Qatada, a Jordanian who could not be deported to Jordan on national security grounds, as there was a real risk that evidence obtained by torture might be submitted against him in his trial in Jordan for terrorist offences. So the answer of the current code is, well, let him not face justice at all. I think that is unwise. And that's been what the debate has been about. There's no real risk that Qatada himself would be tortured. The ruling was despite an earlier finding by the deportation tribunal that the case for Qatada's deportation had been well proved on national security grounds, as Qatada was seen by many as a terrorist spiritual advisor whose views legitimised violence. I give way.
I'm grateful to my honourable friend, and does he agree that it's also extremely difficult for British taxpayers to face the fact that they're also going to have to pay huge sums of money for the security for this individual whose very outlook on life threatens their style of life and existence? And is it right that British taxpayers should be footing the bill for this?
Well, I don't think it is, and I noted an answer given by, I think, the Home Office to a question from the chairman of the Home Affairs Select Committee. And I believe the legal aid bill in the case of Abu Qatada has been over £500,000. So it's a substantial investment in terms of taxpayers' money that's been made in this case. And I think most people in this country would say that was not money that was necessarily well spent. Yes, of course.
I thank my friend for giving way and congratulate for bringing this here today. The Abdul Qatada case particularly got a lot of publicity. Does agree with me that the public sense of outrage at this has not only created a disaffection with the Human Rights Act, but generally with democracy and even this place altogether, just because of that one issue and how powerless and helpless we appear to be to bring this man to the justice he should so surely meet.
I completely agree with my honourable friend, and his intervention is timely and extremely telling. It has undermined confidence in human rights, but it has undermined confidence in Parliament and the ability of Parliament to legislate and to be sovereign and to stand up for Britain. And there's another case, an Albanian man who returned to the UK illegally after being told to leave following his conviction for robbery in his country, could not be deported, despite being convicted of another crime since his return on the grounds of family life that he had established in the UK. A Sudanese man was convicted of raping a 12-year-old girl in the UK. He could not be deported due to the risk that he would be subjected to maltreatment in the Sudan. I think most people would have very little sympathy with a paedophile rapist and would think that broadly he should not be in the UK. And despite being found by a deportation tribunal to pose a threat to UK national security, an Algerian man could not be deported to Algeria due to the risk that he would commit suicide while in custody there. All these cases have caused widespread public concern, which is why a key plank of this bill is that the Human Rights Act should be repealed. Let's just look at the opinion polls. My honourable friend, 1 moment ago, pointed out the level of public concern that there is. For nearly a decade, opinion polls have consistently shown that the British people reject the UK's current human rights settlement. In 2008, a research project by the Ministry of Justice, and let's be honest, the Ministry of Justice, Mr. Deputy Speaker, is not exactly sceptical of human rights as an institution. And it was under the previous government that was not exactly sceptical of European human rights either. And despite that, they analysed results collected between 2004 and 2006, and it found that 57% of respondents agreed that too many people take advantage of the Human Rights Act. Just 14% disagreed. 40% believed the Human Rights Act had caused more problems than it has solved, against 24% disagreed. And despite the Human Rights Act, 56% agreed that this country lacks a shared sense of rights and responsibilities. And it is for that reason that a key plank of the bill I brought today is that we shouldn't just be talking about rights. We should also be talking about responsibilities. For a government-sponsored report on the policy of the then government, it seems to me that this is a less than ringing endorsement of the human rights settlement that the country has today. In May 2010, a YouGov opinion poll found that 53% supported the introduction of a British Bill of Rights to replace the Human Rights Act, against 24% who wanted to keep the Human Rights Act. So I believe in bringing this bill today, I act in line with the majority wishes of this country. In February 2011, a YouGov poll that found that 63% thought the British Parliament and Supreme Court should have the final say on human rights matters, rather than a foreign court, against 25% who thought that it was right that we should be subject to the Strasbourg Court when it comes to appeals. 57% believe that Britain's membership of the ECHR has been abused by lawyers, making spurious cases on behalf of criminals, and on balance, it is a bad thing. Against only 19% who believe that Britain's membership of the ECHR had been a valuable protection against the government ignoring the human rights of the British people, and on balance was a good thing. Yes.
My honourable friend.
My honourable friend is making a very good point, pointing out the evidence from opinion polls. But is it not the case that we all know anecdotally that the European Court of Human Rights and human rights has now tragically become a watchword for abuses in the system? It is now, it has in fact become a joke, and actually that's very damaging for the whole concept of human rights altogether.
I couldn't agree with my honourable friend more, which is precisely why I have brought this bill to the House today. And this February 2011 YouGov poll also found that 55% thought that Britain should leave the ECHR altogether and have our own Bill of Rights instead, with the British Supreme Court as the final court of appeal. Just 24% thought we should remain part of the ECHR. A good way.
Does my honourable friend agree with that opinion poll finding? And if so, why is that not reflected in the bill, that we should be withdrawing from the European Convention on Human Rights?
A very, very good intervention, a very telling intervention. In tabling this bill, as a Member of Parliament, I do so as a lawmaker in relation to the laws of the land. Whether we remain as a treaty is a matter of royal prerogative and a matter for the Privy Council and the Executive of the day. And I've crafted this bill in such a way to leave open that choice to the Executive as to whether they want to remain part of the ECHR or leave altogether. And what I've sought to do in this bill is to put in place the kind of cornerstones and foundation blocks of a uniquely British settlement, with an attempt to enable us to have optionality as to whether we remember part of the European Convention. I myself have grave doubts about the European Convention, but nevertheless I wanted to keep that optionality just in case the government of the day was not prepared to go that far. A good way.
I'm very grateful, and I wholly agree with everything he said so far, but would he not agree, following on from the point from my honourable friend for Bury North, that unless we were to withdraw from the European Convention of Human Rights, even if his bill was successful, all we would be doing is transferring perverse rulings from the UK courts to even more perverse rulings in the European Court of Human Rights, and that it might add an extra barrier in place, but it wouldn't stop these perverse rulings that both he and I object to so much.
My friend makes a fair point, and he's right. The European Court in Strasbourg does make an awful lot of rulings that right-thinking British people would think were entirely perverse. What I have sought to do in this settlement is to take the European Convention out of the UK legal system so it is not directly effective, so it doesn't have to be applied by UK judges day in, day out. That the rulings of Strasbourg are taken out and don't have to be applied day in, day out. He is right. If we remain part of the treaty, then of course, on a case-by-case basis, however many it is a year, I think possibly about 10 a year, there would be rulings potentially against the UK, and the executive would then need to give consideration of putting provisions before Parliament to change that or not. But I think my honourable friend is right when he raises the potential risks and difficulties and challenges highlighted by the issue. I give way to my honourable friend, the member for North East Somerset.
Way, and I want to raise the point not of perversity of the rulings of the European Court of Human Rights, but on the legitimacy of their rulings, because they have no support from the democracy of the United Kingdom, and having foreign judges rule on our laws lacks legitimacy, even if their judgments are sensible.
I have a lot of sympathy with my honourable friend and his position on that, and indeed he will note that from the polling evidence I've read out, a lot of the British people, a large majority of the British people have an enormous amount of sympathy with the issue. And what I hope is if this bill passes its second reading today and my honourable friend were to become a member of the Bill Committee, maybe he might put an amendment down to clarify the provision in question so that that discussion and wider debate can then be had. The polling evidence, Mr Deputy Speaker, goes on. In March 2011, a YouGov poll found 51% felt that human rights laws were bad for British justice. Significantly, there was strong support for rights being dependent on the conduct of the individual asserting them, with 64% rejecting the notion that everyone should be entitled to have their human rights protected, even if they have broken the law themselves. And that's a key point of what I was discussing earlier about the objective test versus the subjective test. And British people instinctively think as my honourable friend, the member for Christchurch, has said, instinctively feel about the issue of coming to court with clean hands. The sort of principles of equity run deep in the psyche of the British people. 75% believe that the Human Rights Act is used too widely to create rights it was never intended to protect. This, again, is a key issue and a key concern that people often talk about. Finally, a YouGov poll in February 2012 found increased concern, with 72% agreeing that human rights have become a charter for criminals and the undeserving. Just 16% disagreed with that proposition. So what I say is that polling evidence highlights the extent to which the British people reject the UK's current human rights settlement. People clearly and consistently do not feel that the right balance has been struck. To restore public trust in our basic rights, the UK's human rights settlement ought to be revised. It's for this reason that I have tabled this bill today. And I think it's worth reflecting, Mr. Deputy Speaker, on the history that the UK has when it comes to human rights. We do have a long and proud history of protecting the rights of individuals against the government. The development of these rights, what we now call human rights, stretches back at least 800 years, from Magna Carta, the Bill of Rights, 1689, the various sort of settlements and acts have changed the Constitution over a long period of time. And many people think we don't have a written Constitution. Of course we do. It's in many different documents. And one of the magic thing about our Constitution is that because it's in various different documents, and because it's not set in stone 200 years ago, like the American Constitution, it's easy to change, and it's easy to keep up to date, and it's easy for our Constitution to bend like a reed in the wind when social change, the breath of air of social change comes across the country. And so I think that it works well in terms of what we had. An individual...
Give way.
Yes, of course.
Thank you, Mr. Deputy Speaker. I thank the honourable gentleman. So your change, forgive me, the honourable gentleman's change is a two-phase change. Phase one is to change it here, and phase two is to change the European Court of Human Rights. So it's actually in accord with what we wish in this country.
Thank my honourable friend for that intervention, and he's right. The European Convention was a document drafted 50 years ago following the tyranny of the totalitarian regimes in the Second World War and the blood that they spilled across Europe. And we ought to have a document which is living. And one of the biggest problems with the Convention is it's not a living document. It's a document set in stone some 50 years ago. And it hasn't kept up or changed with our times. Europe has moved on. The European Convention has not moved on with it. And I think that's a key problem with the whole idea of having written documents like this, or written constitutions, and they can't change over time. The Americans spend an inordinate amount of their time arguing as to whether they have the right to bear arms, which strikes us as absurd. We could change this easily in the UK. I give way.
I'm very grateful to my honourable friend for giving way, because I thought I should remind him that the right to bear arms is actually in our own Bill of Rights, which maintains the right to bear arms because of the need to maintain a Protestant militia, which fortunately has gone out of fashion in more modern times.
And my old friend was absolutely right. When something goes out of fashion in the UK, as he himself will know, we move on and we change things, and we are able to adapt. The Americans obviously copied it from our provisions and are stuck with the continual argument about it, whereas for us it's a part of a figment of our history. So it seems to me that individuals don't just have basic rights, they also have basic responsibilities that reflect the needs of a civilised society to function. And that's at the heart of the social contract that underpins our way of life. It's long been understood that the nature of the social contract will change over time. What is acceptable in one age is not acceptable in another, and vice versa. It is in the nature of the UK's legal and constitutional structure that changes in the social contract can be accommodated peacefully and effectively. As the UK has no formal codified constitution, laws can be passed by this Parliament as required to keep pace with social change. And it's worked well for us. When was the last time we had a revolution? Some centuries ago. When we look across Europe and elsewhere, we see revolutions are commonplace. our Constitution is able and does adapt. It does keep up with the times. And it was with this heritage that we helped with the European Convention of Human Rights, that the UK signed the Convention in 1950. Indeed, the UK played a significant role in drafting the Convention, as many will know. It's developed in the wake of the tyranny and inhumanity that characterised the fascist powers defeated in the Second World War, and also had an eye on the Stalinist terror behind the Iron Curtain. And the purpose of that was to hold the states to a range of basic human rights to prevent ever again the repugnant treatment of individuals seen in Europe during the 30s and 40s. But the UK resisted the idea of joining the European institution that would adjudicate on individuals' claims that the ECHR state had violated their convention rights. The UK was concerned by the potential for unintended consequences and a loss of national autonomy. Different nations have different cultures and diverse social norms unsuited to a one-size-fits-all approach, which is why so often, I think, the discussion that we have in terms of human rights goes hand in hand with the wider discussion we have in Europe. How do we shape our way of life and our own uniquely British identity within the context of a larger organisation across the Channel? For a long time, the binding jurisdiction of the Strasbourg-based Court of Human Rights and the ability of individuals to file claims that their convention rights had been breached was optional for ECHR states. It was only in 1994 that the UK agreed to the jurisdiction of the ECHR, including in cases brought by individuals, becoming a compulsory part of the ECHR. Even then, our agreement was obviously reluctant. The Convention, including the rulings of the European Court of Human Rights in cases to which the UK is a party, is binding on the UK as a matter of international law. As discussed earlier, whether we should remain part of that Convention is a wider question which I haven't sought to answer in this bill directly, although I hope that my honourable friend, the member for North East Somerset, when he serves on the committee scrutinising this piece of legislation, may wish to explore that issue further and in more detail. However, under the UK's dualist approach, treaty provisions do not have force in UK law unless Parliament legislates to incorporate them, and it was long felt that the incorporation of the ECHR into our UK law was unnecessary because UK law already protected rights in the Convention. So then we had the Human Rights Act 1998. Soon after winning power in 1997, the Labour Party brought forward what became the Human Rights Act. The Human Rights Act effectively was a copy and paste into UK law of the text of the ECHR rights that the UK has accepted internationally. And Tony Blair, former Prime Minister, wrote in the White Paper, it will give people in the UK opportunities to enforce their rights under the European Convention in British courts, rather than having to incur the cost and delay of taking cases to the European Court of Human Rights and the court in Strasbourg. It will enhance awareness of human rights in our society, and it stands alongside our decision to put the promotion of human rights at the forefront of our foreign policy. It will be recalled that putting human rights at the forefront of our foreign policy didn't last quite so long, and the whole idea of the ethical foreign policy was soon ditched. But the Human Rights Act lived on and has lived on a little longer. So we had the main provisions of the Human Rights Act entering force in October 2000, and the Convention rights in detail, things like right to life, prohibition of torture, prohibition of slavery, the right to liberty, right to a fair trial. These are mostly very sensible provisions. In fact, most of the European Convention you would not disagree with. The issue is, and has always been, how they're interpreted by a judicially activist court, that is the European Court of Human Rights. The basic rights are sensible, broadly sensible basic rights. It is how they are set out and how they are used which has caused the difficulties. And also, the difficulties have been caused by inserting the Human Rights Code and the Strasbourg Court's rulings directly into our legal system, so that British judges have to apply those provisions in Britain, whether they like it or not. And that's under Section 2 of the Human Rights Act 1998, which is revised in my British Bill of Rights. Section 2 of the Human Rights Act requires British courts, when applying ECHR rights, to take into account any judgment of the European Court of Human Rights that they believe is relevant. UK courts have taken this to mean that they should follow clear and consistent jurisprudence of the Strasbourg Court unless there are exceptional reasons not to do so. And then a real mischief, even evil, is done by Section 3 of the Human Rights Act, which obliges British courts, along with everyone else, to interpret and apply legislation in the UK in a way that is compatible with the ECHR rights in the Human Rights Act, so far as it is possible to do. When introducing the Human Rights Bill, the then government was clear about how radical a change Section 3 would be. It said the bill provides for legislation, both Acts of Parliament and secondary legislation, to be interpreted as far as possible so as to be compatible with the Convention. This goes far beyond the present rule that enables courts to take the Convention into account in resolving any ambiguity in a legislative provision. The courts will be required to interpret legislation so as to uphold the Convention rights unless the legislation itself is so clearly incompatible with the Convention that it is impossible to do so. This rule of construction is to apply to past as well as future legislation to the extent that it affects the meaning of a legislative provision. The courts will not be bound by previous interpretations. They will be able to build a new body of case law taking into account the Convention rights. In other words, the Human Rights Act semi-entrenched the European Convention into our legal system and to our Constitution so that past and indeed future provisions of law have to be read in line with the European Convention or indeed the rulings of the European Court. But more than that, that if the legislation isn't totally incompatible, violence can be done to the language. And that's a real issue and a real threat to the parliamentary sovereignty, which my honourable friend, in his intervention some moments ago, made that point very clear, that it causes distrust among the British people that should be...
I'm grateful to my honourable friend for making this incredibly important point, because it is in fact a constitutional extension of the most extraordinary kind, because it makes the Human Rights Act superior legislation, a concept previously unknown in the British Constitution, with the arguable exception of the 1972 European Communities Act, and that having superior legislation is a direct threat to our Constitution and to the ability of Parliament to bind its successors.
I completely agree with my honourable friend on this point. He's absolutely right. This is, in my view, the worst part of the Human Rights Act 1998, and a key reason that, and a key change that I put forward in this bill.
Will my honourable friend give way?
Yes, of course.
Following on from that last point, does my honourable friend think that his own bill is compatible with Section 3 of the Human Rights Act and is compatible with the European Convention?
I do, because I believe that there is this whole issue about the margin of appreciation and about proportionality. And I think the European Court of Strasbourg has taken a disproportionately narrow view of the whole idea of margin of appreciation. And I think it's a key change that we should make. And we should not be shy in doing this if we're going to get the right settlement for the UK. Because since its entry into force, Section 3 of the Human Rights Act has indeed had far-reaching effect on how British judges apply legislation in the UK. Before this provision, the British judiciary's interpretation of an Act of Parliament centred on the ordinary meaning of the Act's words when viewed in their context, taken with the intention of Parliament when enacting these words. But in his opinion in the leading case on the application of Section 3, Lord Nichols stated in the cases Gaidon and Godin-Mendoza, Lord Nichols stated, the interpretive obligation decreed by Section 3 is of an unusual and far-reaching character. Section 3 may require a court to depart from the unambiguous meaning of legislation the legislation would otherwise bear. In the ordinary course of the interpretation of legislation involves seeking the intention reasonably to be attributed to Parliament in using the language in question. Section 3 may require the court to depart from this legislative intention, that is, depart from the intention of Parliament which enacted the legislation. So I think that that is a critical point in terms of how Acts of Parliament are interpreted. I think that they should be interpreted in line with what Parliament intended, not with what a group of judges from overseas might seek to rule. Another impact of Section 3 is that the courts are empowered to strike down what the HRA classifies as subordinate legislation, what we call secondary legislation or statutory instruments. If it's not possible to read this legislation compatibly with ECHR rights, and primary legislation under which it is made does not prevent the subordinate legislation's incompatibility from being removed. So under the HRA, subordinate legislation includes most legislation that is not itself an Act of Parliament, but which is made under the authority of an Act, including much legislation approved by resolution of each Houses of Parliament. I think that this is a concern and something that should be changed. Section 6 of the Human Rights Act obliges all public authorities in the UK to act in compliance with the European Convention rights in the Human Rights Act, except where an authority cannot act compatibly due to a provision of primary legislation, or where the authority is giving effect to provision of or made under primary legislation that cannot be interpreted in a way that is compatible with Convention rights. So in other words, it doesn't just reach into our legal system, it reaches into our public authorities as an obligation that they need to follow as well. So we can see that broadly the Human Rights Act is incredibly far-reaching in what it's done. On that note, I think the right thing would be to come to the key changes that I am seeking to make in this bill to deal with the mischief that I have set out. I think we need to restore balance in its entire area. And so doing that, this bill would repeal the Human Rights Act and it would replace it with a new settlement. And the new settlement would draw on the framework of the Human Rights Act, but it would vary it in relation to the key concerns that have arisen. So, if you like, there are 10 pillars to the reform which I am proposing. Number one, the UK Supreme Court should be the final court of law for human rights matters. Number two, serious foreign criminals... Yes, of course.
Because this follows on from my earlier intervention. In clause 7 of the bill relating to acts of public authorities, a public authority is specifically stated to include a court or tribunal. However, in the section that relates to the application of the Convention, which is clause 17, although it states it includes any public authority, there is no description or explanation there that explains that a public authority in that clause includes a court. So I just wonder whether, in fact, what my honourable friend has just said is borne out by what's actually in the bill.
And for that intervention, he makes a powerful point. And I hope that he too will consider joining the committee to scrutinise this bill in order to ensure that we get the right balance. And I hope that he will put down amendments to take forward the discussion and the debate, perhaps also in relation to whether we should stay as part of the treaty, and maybe he might join forces with my honourable friend, the member for North East Somerset, on that issue. I think these are important issues that should need to be explored. And as I say, this is a second reading. It is if you like, a sighting shot as to what a British Bill of Rights could look like. And I have no doubt that in the Bill Committee it can be dramatically improved and made even more ideal from the point of view of the kind of new settlement that we could have. So as I was saying, the first principle is that the UK Supreme Court should be the final court in UK law for human rights matters. And second, serious foreign criminals and persons in the UK illegally should not be able to avoid deportation using human rights claims as they have done so in the past. Third, that the right to family life should not be available as a tool to avoid justice and escape answering criminal charges. Fourth, that suspected foreign terrorists should not be able to subvert the national security or our personal security or avoid deportation using human rights claims. Fifth, freedom of thought, freedom of conscience and freedom of religion should be protected to a greater extent than they are today. I think we've seen too much attack on people's thoughts, on what people think, what people feel, what they believe, too much in a way of aggressive secularism which has sought to attack the Church attack people who have deeply held religious beliefs. We've seen it with the Plymouth Brethren and the Charity Commission. We've seen it with constant attacks on church and on religion in Parliament and outside Parliament. And I think we must ensure that there is a space for people to have religion and religious beliefs in this country, that they should be able to set out and preach what they think, that they should be able to have the rights of speech better protected than it is today. Yes, of course.
The Honourable Member perhaps reflects on a broader application of this, whether the Honourable Member would see this as applying, for example, to Islam as well as to Christianity in terms of freedom to speech, freedom to express what people believe, the inability of the state to interfere in personal beliefs.
Yes, I would. I think it is important that every British citizen should be able to have a belief. I may be a Christian, but I think we need to respect people who are Muslim and have follow the Islamic faith and the Jewish faith, the Catholic faith, Protestant Christianity as well. These are all important. Not that it should be unlimited. I've been very careful in the relevant provision to say that freedom of religion does not extend to inciting physical harm or undermining national security. We cannot have a situation where freedom of religion could possibly be used to promote terror, which too often it has done. So there is that important limitation. But within that context, it is important that we do have religious freedom. Yes.
One friend agrees with me that the British public saw no mischief being created in British culture prior to our entering into the Convention. It is only since the Convention they appear to have seen a slew of very wealthy barristers getting much wealthier on doing a lot of things which seem to subvert our traditional culture, when we saw there was no apparent reason for bringing this in the first place, which is a great cause of concern and confusion for the public.
I thank my honourable friend for that intervention. She's absolutely right. On social media, I have been roundly criticised by people, oddly, who seem to be lawyers in this area. And I rather wonder if part of the reason for their criticism is because they wonder if I might be threatening their livelihood. And they're milking the system and milking the legal aid budget for every penny and pound that they can get out of it in order to put forward their spurious, too often spurious, human rights claims. So I have to say, as a former lawyer myself, I have very little sympathy for lawyers that seek to milk the taxpayer to further and fatten their own wallets. I think that is important. And so I've been quite clear in my responses to people that they have something of a conflict of interest when it comes to the human rights issues and their own livelihood. Now, the sixth pillar is that the right to vote should not apply to convicted prisoners, a matter on which this House has expressed concern before now. The seventh pillar is that legislation passed by Parliament should only be changed if Parliament so decides. Courts believing that legislation breaches human rights should declare their opinion, yet Parliament should make the final decision on whether the laws ought to be changed. 8. Public authorities should not be penalised for applying legislation that is approved by Parliament, because too often they have been, and it creates uncertainty and makes their life extremely difficult when they think they're doing what they're told to by Parliament, and suddenly they end up with a human rights claim and a member of the bar pursuing the compensation culture on their behalf, as well as his or her own behalf as a lawyer, in order to get money out of the taxpayer. And 9. The UK law should not be automatically interpreted in line with the rulings of the European Court of Human Rights. In deciding human rights cases, UK courts should take into account centuries of common law rulings from the UK and elsewhere in the common law world. And finally, the UK social contract isn't just about rights. It's also about responsibilities, and the contract should include responsibilities as well as rights.
Would the honourable gentleman agree?
Yes, of course.
Thank you, Mr Deputy Speaker, and I thank my honourable friend for giving way yet again. I'm not a lawyer, but it seems to me there is a worry here. If your principles, forgive me, the honourable gentleman's pillars, are actually put into law, will anyone in this country who disagrees with them and wants to avoid extradition, say, would anyone have any rights whatsoever to go to the European Court and say, this is wrong, can I actually appeal to you, and that will delay the process? Will that be negated by such an act?
The answer to that is, if we remember the treaty, then yes, of course they could go to the European Court of Human Rights, which is why the issue as to whether we remain part of the treaty or not is an important issue. Nevertheless, it wouldn't be in the UK legal system. So they wouldn't be able to stand on those rights, those European rights, before UK courts, nor seek relief before the UK courts, unless it was British rights under the British settlement. That is the key part of what you might call the dualist approach. And obviously, the Strasbourg machinery clanks more slowly, and also doesn't take every single case going, as the British courts are required to. So I think one would see a massive reduction in the level of cases, but also in the level of public concern on that. Now, let me just talk about the detailed provisions of the bill. The UK rights and UK responsibilities. It doesn't just copy the text of the ECHR rights. This is a UK Bill of Rights, and the rights it contains are referred to as British rights. And the ECHR text is varied where needed. And let me just take, Mr. Speaker, the House through a few of the major headline changes. The main qualification is the right to life is brought more into line with domestic law on the ability to use force in self-defence and prevent crime. The prohibition of forced labour is clarified so it explicitly does not prevent people being required to undertake work or training as a condition of receiving welfare benefits. The rights to respect of private and family life would no longer be available as a tool to avoid trial and punishment for criminal acts. The scope for limiting the right to manifest one's religion or belief is reduced. This right is only limited to stop causing the causing or incitement of physical harm to others so far as is necessary to protect public order. It's made clear that the right of free elections does not confer a vote on convicted prisoners or those who are not British citizens. I hasten to add, we do have constitutional settlements that allow European, Irish, Commonwealth citizens to vote in certain cases, and those are matters for Parliament to extend as it sees fit. The basic right should be that British citizens should be able to vote who are not prisoners. And the rights in the bill should not be used by those who are not British citizens to delay or avoid their deportation or extradition from the UK. They could not be used to prevent public authorities from taking action in relation to a person to uphold national security or public safety where the authorities reasonably believe that there is a clear and present danger to national security or public safety presented by that person. Though such action would not include the killing of that person, because we don't believe governments should go around killing people, unless it was already allowed under the right to life provision, or the use of torture or inhuman, degrading treatment or punishment. So it is very much getting the settlement right that we can put national security at the heart of our constitution and our constitutional rights, and ensure that government is able to protect our national and personal security, which, to my mind, is the first call of government and the first call that government should take. In addition, the bill includes rights not set out in the ECHR text. These are in England and Wales to use force against intruders in a home, so long as the force is not grossly disproportionate, the right of a parent or guardian to challenge in court without undue delay the lawfulness of any removal of a child from their custody, where the child is placed in custody by a public authority, and the right for a British citizen to challenge extradition to another country on the basis that they should have a right to trial in the UK if the alleged crime is committed while the person in question is in the UK. On the other hand, the bill doesn't displace basic rights in the UK legal order, so all the other constitutional documents that we have from Magna Carta onwards still remain there. This is very much an additional baseline of rights that apply in our nation. And alongside the rights, the bill includes a list of basic individual responsibilities. A person's basic responsibilities include obedience to the law, rendering civil or military service when his country requires his support or defence, supporting, nurturing and protecting minor children to the best of ability, respecting and upholding basic public order without placing himself in significant danger, seeking to support himself without recourse to a public authority, to the best of his ability, including but not limited to seeking work or gainful employment where he is able to do so, and also rendering help and assistance to other persons where reasonable and to the best of their ability, including but not limited to help for elderly and disabled persons. These responsibilities are not direct obligations on individuals, nor would they automatically confer new powers on public authorities. Instead, they will be taken into account when the court is considering a UK right.
Yes. Responsibilities. Thank you, Mr Deputy Speaker. My honourable friend's been very generous with his time this morning, and I appreciate that. Article 23, which sets out these responsibilities, which my honourable friend has just read out for the benefit of the House. I just wonder how he thinks that that would be enforced if it was felt that an individual had not followed these basic responsibilities. I mean, we already have courts that you appear before if you break the law. What's the purpose, and what further will be achieved by putting this in the bill?
Thank my honourable friend for that intervention. This comes to the key issue of determining whether a person should be able to stand on a UK right. British courts must take into account all the facts and circumstances of the case, including the conduct of the person seeking to assert the UK right, including his adherence to the responsibilities in Article 23, whether it is fair, equitable and in the interest of justice for such a UK right to be applied in relation to the question at hand. This is effectively the heart of the subjective test that my honourable friend, the member for Christchurch, referred to earlier as come to equity with clean hands. And I think it's a really important point. And it goes to the heart of this bill, that rights must be matched by responsibilities. If you have not discharged your responsibilities, that is taken into account when you seek to stand on a right. In other words, if you've broken your half of the social contract, that comes against you when you then seek to assert the part of the social contract or rights that you then want to rely on. And I think it's right that judges and the courts should be able to look at the case in the round in order to determine whether a person should be able to avail themselves of those rights. As I said, you should not be able to use the right to family life to stay on the run. And that's a basic part of the subjective test. And this is really intended to help rebalance the approach to human rights towards a more subjective application to particular cases, with the aim of ensuring that justice and fairness are not trumped by this sort of rigid, objective view that has been characterised the European Court of Human Rights jurisprudence. These broader considerations should include whether a person is seeking to assert a basic right has in fact kept his part of the social bargain or the social contract. And I think that is incredibly important. And I think deep down, if you talk to a person in the street and you talk to them about a social contract, they'll say, well, there are two halves, aren't there? There's rights, but there's also obligations or responsibilities, as I've called them. So it recognises the duality of the social contract that lies at the heart of our society. And when it comes to interpreting UK rights, the bill removes the provision for the Human Rights Act that requires British courts, when interpreting and applying the rights in the bill, to take into account rulings of the European Court of Human Rights. Instead, the bill makes clear that UK courts may take account of judgments from a wide range of sources, including but not limited to the Strasbourg courts, with courts of common law jurisdictions getting top billing. And rightly so, because we're a common law country. And there's a common law world out there that we helped establish in the days of our empire that now proceed with common law jurisprudence. Australia, New Zealand, the United States, Canada, these are all countries that have common law foundations, have given a lot of thinking to a lot of the issues that often then come before our courts. Why would we not take them first before we looked at the civil law jurisdictions of Europe? And I think that that is the right kind of balance for us to have. So this bill removes this provision of Section 3 of the HRA, which requires UK courts to interpret and apply legislation in compliance with human rights so far as it's possible to do. Instead, the courts are directed to give legislation its ordinary and natural meaning. Where the meaning is ambiguous, the courts will typically presume that a possible meaning that complies with UK rights is intended. In that way, you give primacy back to Parliament. You restore the confidence of the British people that Parliament decides. And you have a uniquely British Code of Rights that is right for this country. Yes, of course.
My honourable friend, surely you give confidence to the British people that the British people decide, that it is them through their Parliament rather than Parliament in isolation.
I agree. I am happy to be corrected by my honourable friend in terms of the emphasis. He's absolutely right. We're not here to represent the government to our constituents. We're here to represent our constituents to the government, to Parliament, and ensure that their will is carried through. And I think that that is central, a very central part of what the bill I presented today is all about. We need to restore the sovereignty of Parliament when it comes to human rights. We need to restore confidence in human rights with a settlement, a uniquely British settlement that the British people will respect and will trust, with the right balance of rights and responsibilities. And also with the right balance when it comes to ensuring that Acts of Parliament aren't just turned over by the courts, but the courts apply Acts of Parliament passed by the lawmakers, which is the way it should be. The horse should, in fact, always go before the cart, not the other way round. And the other thing which strikes me as very important is we need a right settlement for the UK, a settlement that people can have trust and confidence in, so that they will feel that, once again, it's a British settlement for the British people that strikes the right balance and has the right balance and fairness that, to my mind, is the cornerstone of the British psyche, the British way of life. And on that note, Mr Deputy Speaker, I move this bill.